of the Medical Board of California. I'm Dr. Ron Lewis, chair of Panel A, and so welcome everybody. Next order of business will be to establish a quorum, so we'll have a roll call to establish a quorum. Ms. Richards?
Dr. Hawkins?
Here.
Ms. Lubiano?
Here.
Mr. Warmoth?
Here.
Mr. Watkins?
Present.
Dr. Yip?
Here.
Dr. Lewis?
Present.
We have a quorum.
Thank you. We have a quorum. First item of business. Okay. I keep forgetting that. The first item of business will be going into an open session in the oral argument of the non-adopted proposed decision of Peter Paul Koenig, M.D. And I will now turn this over to the ALJ.
Good morning. I'm Administrative Law Judge, and I'm Teresa Burrell, and I'm going to be presiding over this with the Panel A of the Medical Board. Let's go on the record. The record is now open in the oral argument of the matter of the petition for penalty relief of Peter Paul Koenig before Panel A of the Medical Board of California, case number 800-2018-04719, and Office of Administrative Hearings, case number 2019-050844. The Office of Administrative Hearings also assigned another number to this, and that number is OAH case number 2019-100267. This hearing is being held on November 7 of 2019 in San Diego, California. Again, I am Administrative Law Judge Teresa Burrell. Now, why don't we have appearances for the Attorney General's Office?
Good morning, Deputy Attorney General Carolyn Westfall.
Okay, I don't see anyone at the petitioner table. Is Dr. Koenig here? Ms. Westfall, do you have any information about whether he's coming? I think I saw in a brief that they were submitting on the papers.
That's correct, Your Honor.
Okay. Well, then I'm going to give you your full 20 minutes like we did the other day, and I'm timing it with my phone. So why don't you go ahead?
Okay, thank you. We're here again on a petition for early termination of probation, and the board has asked for argument from both sides on the issue. And as always in these proceedings, the burden is not on me, but it is on the petitioner to prove to you that he should have his license fully restored. He has that burden by clear and convincing evidence. With that said, as the judge pointed out, Dr. Koenig is not actually present here today. Despite his own burden of proof, he's chosen to be silent before you today and submit on his papers alone. When looking to determine whether or not a physician placed on probation should have their license fully restored, the California Code of Regulations offers guidance to you as to what you can consider. You can consider the nature and severity of the underlying acts. You can consider the time elapsed since the acts and any evidence the petitioner has produced of rehabilitation. I start always with the nature and severity of the underlying acts, which I suggest to you is one of the most important things for you to consider in these proceedings. What exactly did this physician do to be disciplined by you in the first place? This is such an important point for you to consider because it's from that conduct that he must show that he is rehabilitated to the point to overcome your prior adverse judgment. So what did he do to find himself placed on probation to begin with? I did not handle Dr. Koenig's original accusation that resulted in him being placed on probation. I also did not handle the underlying petition hearing for early termination of probation that was non-adopted by you. So like you, I reviewed this case on the four corners of the record. I saw, as you did, that Dr. Koenig was placed on probation. He resolved his He resolved the underlying accusation by way of a stipulated settlement that was subsequently adopted by the board on August 12th of 2016. In that stipulated settlement, he admitted the second cause for discipline, the title of which is a conviction of a crime substantially related to the practice of medicine. Now, in the underlying petition hearing, Dr. Koenig argued that the board need only consider his rehabilitation from a trespass conviction. Quote, certainly not a severe charge, as he claims. This is, of course, both misleading and incorrect. In his stipulated settlement, Dr. Koenig admitted to more than just a mere trespass. Dr. Koenig was disciplined for more than just a mere trespass. A simple reading of the second cause for discipline that he admitted there was a factual basis for incorporated all of the allegations contained in the first cause for discipline, the title of which was sexual misconduct. Looking at all four corners of that first cause for discipline showed that Dr. Koenig performed a so-called breast exam on a long-time patient despite the fact that she told him she didn't need one that day. And during this so-called breast exam, he rubbed his body against hers. He twisted her nipples. He told her she was his favorite patient, and he kissed her on the mouth. Despite the fact that he had performed 12 prior breast exams on this patient, obviously this one was different, and she reported it to the police. He was charged with a sexual battery, and it was through a plea bargain that he pled to a lesser charge, the mere trespass, in exchange for 1 year of counseling for sexual compulsive behavior. Now, there are a lot of reasons a DA would dispose of a case in this manner, and we can all sit here and speculate as to why the DA permitted him to plead to a lesser charge. But we can't, and we shouldn't, because it's not in the four corners of the record of this case. And quite frankly, it's quite inconsequential to these proceedings. What is in the record is his admission to that second cause for discipline that incorporated the first cause for discipline. So the underlying facts that led to his criminal conviction can and should be considered by you here today. And those underlying facts speak to the gravity and circumstances in this case. It is from that conduct that he must show sufficient evidence of rehabilitation to terminate his probation early today. It has been 5 years since Dr. Koenig was accused by his patient of sexual assault as she sat in his office, disrobed, seeking legitimate medical treatment. So what evidence of rehabilitation has he shown you? In looking at the four corners of this case, it appears that Dr. Koenig has basically shown you that he has complied with the terms and conditions of his probation thus far. He's determined that, well, it's no longer okay to kiss my patients. The terms and conditions of this probation were designed to protect the public. The terms and conditions were designed to last 4 years, and which include the requirement that he have a chaperone for all female patients, so none of his other female patients can be sexually assaulted by him. His terms and conditions of probation also included a psychiatric evaluation by a board-appointed psychiatric evaluator. Not surprisingly, during his required psychiatric evaluation, the evaluator also recommended he have a female chaperone during the pendency of his probation. I submit to you today that simply complying with the terms of your probation does not in and of itself show rehabilitation from such a significant boundary violation. 4 years of probation was and continues to be necessary to protect the public. The board should not place the needs and desires of a fallen licensed over its duty to protect the public. And in this instance, the board should deny the petition and adhere to the recommendations of its psychiatric evaluator. Continuing to require oversight over Dr. Koenig, particularly in the form of a female chaperone with his female patients, be necessary and appropriate for the remainder of his probationary term. Thank you.
Thank you, Ms. Westphal. Do any of the panel members have questions for Ms. Westphal?
Anybody?
I think Dr. Lewis, I saw your hand go up.
Yes, I have two questions for you. You keep referring to four corners, and I'm a little confused about what you mean by four corners since you've mentioned it multiple times.
Right. When a case is non-adopted, the board's required to consider only the case that the evidence and the record from the hearing. And so I'm not adding any new evidence, and the other side should not as well. That's my point, is that we look at the record, and this is what it told us.
Okay, and the second question is, you made a comment about the previous DAG, I think, about were you in disagreement of your previous colleague, or something about the previous person?
Right. I was referring to the DA, the district attorney who handled the underlying criminal case.
Criminal case. Correct. And that what? You did not agree with them, or?
No, my point is that we can't. We don't know why the DA allowed a plea bargain from a sexual battery to a trespass, but the other side argued throughout the hearing below that it's just a trespass. It's just a trespass. That's what the DA gave, and I'm suggesting to you, as the Business and Profession Codes allows us to consider the underlying events that led to the conviction. But even aside from the law that allows us to do that, he admitted there was a factual basis for that first cause for discipline, the sexual misconduct.
Okay, thank you. That clarifies.
Any other questions? Okay, Dr. Yip.
Thanks for the comment. Just that since you mentioned you're not the initial DA on the case, and also have you taken into consideration the fact that our probation monitor actually is the one that recommend him to apply for early termination? Now he's the one that actually have been dealing with him every so often, and you have not. So,
right. To be quite honest, I don't consider the fact that the probation monitor recommends this, because the law allows everyone on probation to petition for an early termination, regardless of whether or not they're even in compliance with their terms of probation. And so it's my understanding that probation regularly informs probationers that they're eligible.
Any other questions? Okay, go ahead, sir.
David Warmoth. I find the cause for why the doctor was before us a very serious matter, but I think we're also talking about a difference of 9 months at this point between when the probation would end and his request to end it now. Does that have any bearing on your thoughts here?
My response to you would be, well, if it's just 9 months, then why not let him complete it?
Okay.
Any other questions? Ms. Westphal, I did want you to maybe get a chance to clarify something, because I didn't want the panel members to be confused. You were not the district attorney, but you were also not the deputy attorney general who negotiated a settlement or that participated in the probation, the last hearing, right?
Correct.
Okay, so I just want to make sure that you understood everyone. Did that cause any more questions? No.
If I could just point out, another reason for pointing out sort of the four corners of the record is in the petitioner's papers, there was some additional arguments, or at least in a footnote, talking about things that are outside of the record, and that would be inappropriate and things you shouldn't consider. What he was thinking, why he entered into settlements, for example, is not part of the record. If he didn't testify to that at the hearing, it's not part of the record. And so I wasn't at the hearing. I didn't handle the accusation. I cannot bring forth any information that's outside of the record because, like you, I only know what's in the record, which is what would be appropriate for all of us to be considering today.
Okay, does that raise any other questions for the panel members?
Actually, it does. David Warmoth, once again. Does that apply? I think they mentioned a case law that would say the fact that he has not admitted to what occurred was actually a good thing. Is that something that is part of the record or is not?
That's correct. A review of the transcript would suggest that he actually wasn't even questioned really about the specifics of the underlying allegations, but it's my understanding that throughout the proceedings he has denied them, except in that stipulated settlement where he admits there's a factual basis for both the first and second cause for discipline, and of course the fact that he pled guilty to a charge, albeit a lesser charge.
Agreed.
Go ahead, Dr. Lewis.
Dr. Lewis, and what is the reason why the original DAG could not be here? Because it's a little unusual for me to hear it from someone who wasn't actually there. Although you know the case, could you tell us why?
Are you talking about the original accusation case or the petition hearing case? It was different
Petition.
DAGs on both.
Yeah, the petition hearing case.
I think in terms of just our availability for these hearings, and so when the DAG is unavailable, another DAG handles it, and I assure you that I am perfectly prepared and I've reviewed the
Yeah.
whole record, so I could answer all of your questions today.
Okay.
Any more questions? All right, there being no questions, the argument is submitted, and the matter is closed, and then the panel's going to go into closed session after everyone leaves the room.
Thank you.
And off the record.